I call Charles Chauvel.
Thank you, Mr Speaker. I wonder if I could follow the habit adopted by the previous Speaker and make a reference to you briefly in your previous role. I was standing outside the entrance to Bowen House yesterday looking across at our magnificent new Supreme Court, and it was something to be very proud of to see your name emblazoned there as the Minister responsible for laying the foundation stone, sir. Mr Speaker, the aim of this bill is to amend the Judicial Conduct Commissioner and Judicial Conduct Panel Act 2004, chiefly to achieve two things. First, to provide for the office of a Deputy Judicial Conduct Commissioner, and secondly, to provide that the Commissioner himself, in addition to the existing remedies that he can grant under the legislation, may decide to take no further action on a complaint received by him. There's another purpose, as we've heard, to the legislation. It will amend the Judicial Act to raise the maximum number of associate judges who may hold office at any particular time from 6 to 9. As with much recent legislation in this sector, including the bill that the House has just read a first time, the Child and Family Protection Bill, the Judicial Matters Bill originated under the previous Labour-led government. And the history of the legislation is this, sir. It was introduced on the 25th of June 2008, read a first time and referred to the Justice and Electoral Committee on 22 July 2008. Having been carried forward into the current Parliament, the committee reported on 18 May last year, and today the bill comes back to the House. Mr Finlayson adverted to the what I might call the irony in the fact that the Judicial Matters Bill is now sponsored by him as a National member, because Hansard shows that National opposed the bill on its first reading. And it's interesting to read National's objection set out in his customary learned fashion by National's then Shadow Justice Minister, Dr Richard Worth, because Dr Worth thought that the bill would do nothing to improve judicial productivity, and because it would not improve productivity in his view, it was undesirable. Well, of course, sir, the reason that a Judicial Conduct Commissioner is constituted is not to speed the throughput by judges of their reasons for judgment. It is to maintain and, if possible, to enhance public confidence in one of the three pillars of government, the judicial branch. Accordingly, it is something to strengthen confidence in the administration of justice. And I have to say that there's every reason to suppose that under the able stewardship of David Gascoigne, the present holder of the Conduct Commissioner's warrant, the office will fulfil its purpose. Sir, the Judicial Conduct Act established an office called the Commissioner, appointed by the Governor-General after consultation with the Chief Justice on the recommendation of the House. The Principal Act does set out a process for the receipt and processing of all complaints against judges to be managed by the Commissioner. When the Conduct Commissioner receives a complaint about a judge, he can either dismiss it if it's outside jurisdiction or if it's vexatious. He can pass the complaint to a judge superior in office to the one about whom the complaint was made, or he may appoint a judicial conduct panel. The last course of action obviously only would occur in serious cases where there's a possibility of the dismissal of the judge. The membership of a conduct panel, determined by the Attorney-General after consultation with the Chief Justice, can consist of the following persons: 2 judges, or a judge and a retired judge, or a sitting or retired judge and a practising lawyer, and a lay member. The bill now before us would establish the new office of Deputy Judicial Conduct Commissioner, appointed by the Governor-General on the recommendation of this House, after the Governor-General has received advice that the Attorney has consulted the Chief Justice on the recommendation. Generally, the function of the Deputy Commissioner is to carry out the functions of the Commissioner in relation to complaints during the absence from office or the incapacity of the Commissioner or the vacancy in office of the Commissioner. It's probably sufficient for present purposes to say that the operation of the legislation to date has demonstrated the need for the Deputy's position and the manner of appointment set out by the amendment seems entirely appropriate. The amendment bill also gives the Conduct Commissioner a power to take no further action in respect of a complaint if the Commissioner is satisfied that further consideration of the complaint would, in all the circumstances, be unjustified. This is in addition to the 3 current powers held by the Commissioner, which I listed earlier. Again, experience with the legislation to date, sir, indicates that the amendment is highly desirable. It makes no sense for the Commissioner not to have this power, and it was an omission in the original bill. Mr Speaker, Section 26C of the Judicature Act 1908 provides that the Governor-General may from time to time by warrant appoint fit and proper persons to be associate judges of the High Court. Associate judges have a specialist and only civil jurisdiction, and they undertake a range of companies and insolvency work. They have extensive jurisdiction in interlocutory matters, including summary judgment applications, and they have jurisdiction to assess damages. Some lawyers present in the House will remember, as part of their training, going up to the Masters Court for bankruptcy or call-over. Others, perhaps of a newer vintage, will only remember the Masters. I'm not deliberately not looking at Kate Wilkinson when I make that reference. But they were, of course, formerly known as Masters of the High Court, and they were in those days appointed for fixed terms. I believe it was a 5-year term. And as the attorney has pointed out, they didn't have a role in the Judicial Committee, where he and I have both had the privilege of appearing. From the 20th of May 2004, Masters were renamed Associate Judges and began to serve on the basis of permanent tenure. The maximum number of Associate Judges is 6, although part-time Associate Judges may be appointed. And Sir, Clause 17 of the bill would increase the maximum permissible number of Associate Judges from 6 to 9. As we've heard in the speech from the attorney, the Justice and Electoral Committee received one submission only on this legislation, and that was from the Chief Justice, and it was generally supportive of the bill. As is customary, her submission was made following consultation with the heads of bench of the other superior courts, the Court of Appeal, President and the Chief High Court Judge. Now, only one amendment in the end was recommended by the committee. As the committee notes in its report, new Section 15A would allow the Conduct Commissioner to take no further action in respect of a complaint on the ground that further consideration of it would be unjustified. The committee recommended inserting a new clause to clarify that where the Commissioner has exercised his or her power to take no further action on a complaint, the Commissioner is not required to refer the complaint to a head of bench. Because the Conduct Commissioner is not entitled to dismiss a complaint on the ground that further consideration of it would be unjustified, without this amendment, the Commissioner would arguably be required to refer such complaints to the relevant head of bench, and that is clearly a nonsensical situation, sir. Mr Speaker, in summary, Labor continues to support the amendment, including the change recommended by the Justice and Electoral Committee. We do not know why it has taken the Attorney-General since May last year, when the committee reported, to prevail on his Cabinet colleagues to allow him to bring the bill back to the House. But whatever the reasons for that delay, we are pleased to see its return, and we look forward to its speedy enactment.
I call Simon Bridges.
Good to take a call on this bill, which does a few things that I want to just talk about briefly, and then perhaps briefly talk about some matters of principle. It of course creates the position of Deputy Judicial Conduct Commissioner, and it's